Okay, so we're going to go ahead and get started. For those of you online, thank you for waiting. So we're just sort of waiting for pizza to show up, but we might as well go ahead and get started. So when the pizza arrives, just feel free to take some, and we can uh, continue the event as people are getting pizza. So, as you may have noticed, we did have a last minute substitution. So, one of our originally scheduled guests was Laura Webb from Osler, and unfortunately, she couldn't make it. So, Ryan Bencic agreed to sub in. So, thank you very much. So, I'll introduce our three panelists. Ryan. So Ryan Bencic is an associate at Harper Gray, where he focuses on representing startup companies with respect to corporate and financial issues. Before joining Harper Gray, Ryan co-founded a legal tech startup at a succession private equity fund. Oh, and the pizza's here, so I'll give the introductions, and you guys can get pizza. So I was saying, Ryan is not only a lawyer, but also an entrepreneur. He started a legal tech startup and a succession planning private equity fund, and he draws on this business experience to provide practical advice at all stages of the business life cycle. Um, Katie Chandler is a partner at Fasken, providing strategic counsel to companies in the technology sector on a range of issues, from inception of the business to the growth and procurement phases, advising private companies on a range of business transactions and commercial activities. Katie assists with startup and incorporation issues, debt and equity, angel and venture capital financings, mergers and acquisitions, and IT licensing and development. Finally, Kellen Voyer is the founder and principal of Voyer Law. Kellen is qualified in British Columbia, Nova Scotia, and California. He trained in Silicon Valley before establishing Voyer Law in 2013 with the aim of seamlessly providing US and Canadian legal services. He combines legal knowledge with business acumen and sits on the boards of multiple startups. So with those introductions out of the way, I do have some prepared questions that our panelists are going to be answering, but why don't we go ahead and get started with the questions, but you guys just go up and maybe sort of as unobtrusively as you can just get pizza. So anybody wants pizza, now's the time to get it. I will hand over the microphone.
Okay. You want a vegetarian slice I could have? Yeah, did you get me vegan or what?
It's Vancouver. There's a vegan option.
I don't mind.
It's a free range vegan on the pizza.
Okay, so why don't we go ahead and get started, because we do have allocated time. So start off with a just sort of a kind of a softball introductory question. So while people are getting pizza, I would like the three of you to just describe your practice in your own words.
My practice involves doing mostly US and Canadian cross-border work for early stage tech startups. Every day is super varied. So it could be financing rounds, could be figuring out how to kick out that problematic founder, could be tech licensing, could be privacy. It's really anything that comes up full life cycle. Being a startup lawyer, at least for us, we kind of have to do everything. So most of our team's well versed in employment or IP or privacy or whatever it is. And most of our days are dealing with whatever unique issues come up for our clients.
So I would describe my practice. So as was introduced, I'm a partner in the technology group at Fasken in Vancouver. I would describe myself as a corporate lawyer for technology companies with a focus on venture financing and M&A. And so I also sort of describe myself as having quite a transactional based focus in terms of most of my days I have at least two to four different transactions on the go, a couple of financings, maybe an M&A transaction. And so that's going to be, because we work with startups and right from incorporation, that might include, friends and family early stage financing rounds, which are quite simple and pretty quick to sort of paper and get completed, all the way to more complex, Series A, B, C venture financing deals, which have, preferred share rights and much more complexity to them, as well as a fair bit of M&A, as I said, which again will range from smaller, acquisitions of small companies by our clients, perhaps, to those kind of billion-dollar exits on the really like large size of transactions. So a real range. So that's a bit of my day-to-day.
I'll keep it a little bit simpler and just say there's a lot of overlap pretty much between what Kellen and Katie have both said. I like to describe my practice as being an external general counsel for startups, or I'm a business lawyer for startups or tech companies, or we help them grow and scale. So we help them from the early days. We help them with early fundraising rounds, later stage fundraising rounds. A lot of the time this last year, as the fundraising markets have been a bit quieter in Canada and around the world, but seems like seemingly in Canada, we've been spending more time helping folks get to market, scale, get service agreements out, protect intellectual property, just try to get the whatever it takes to put a fishing rod in the water and start getting traction and selling and getting revenue through the door, which a lot of people forget that the original venture capital is just good old-fashioned sales.
All right. Thank you very much. So my first sort of substantive question is all three of you, your practice focuses on startup companies, either representing startup companies in a business sense or helping them get financing. So how would you say that working with startup companies is different than working with larger, more established corporations?
Yeah, there's a lot of overlap. So in many ways, I mean, you probably want to care about things like intellectual property, sales, papering agreements in terms of ownership or equity. I mean, there's a ton of overlap in the middle. Where they probably differ is the later stage companies probably have a lot more going on the corporate side. They're more established. There's more stakeholders to get approvals from. If you want to make any changes, you probably have to follow 1 or 2 or 3 or 4 rule books and side letters. And there's all sorts of coordination to update someone's options or to grant more options or to hire someone really awesome. You've got more robust structures in place, but it's a little bit harder to move. Whereas on the other hand, startups are a little more nimble. They're way more flexible. Chances are there's fewer stakeholders, if any, that really need to approve things other than whoever has the most shares in a cap table, the equity table. And so a little bit more flexibility with startups, but there's also a little bit less certainty. There's not as much direction. They don't know what's going on. Sometimes they just ask, what should I do? And you have to ask them, well, where do you want to go? Whereas big companies already know where they're going and you're helping them get there is, most cost effectively.
Yeah, I agree with all of that. And actually, just to jump on the point you were saying about cost effectively, I think that's something that comes to mind for me in terms of working with my startup clients, as opposed to the more established tech companies that I work with, is the cost sensitivity. It's you can't ignore the fact that it's there. And so it's really about being able to provide helpful legal advice through that cost efficient lens. And I think that really also promotes as a lawyer, even as a junior lawyer, learning to be a really practical lawyer. And so being able to talk to your client about what their objectives are, understand what the major risks are. And sometimes, the solution that your client's looking for may not be the best and perfect solution. That may just not be a viable option for them because of the costs associated or whatnot. So it's about being able to find the most practical way forward to meet and achieve the needs while mitigating the risks that you might be exposed to. On a similar note, I think the other part of that I think kind of comes with the startup practice is being more reactive and nimble to what your clients are doing, because sometimes, again, often because of those cost sensitivities, clients will just go ahead and do things. They'll draft up terms of service that they found on the internet and, put their own company name on it or something like that. And they'll sort of come to you and say, well, we've been using this, we've been using these terms, or we just did this contract ourselves with this, service provider, and now it's not working out. And so you kind of have to be able to react to that and work with that and go with it and be prepared for those things that are going to be thrown at you and help them find creative and optimized solutions forward.
Yeah, I had a client the other day, they're like 7 figures MRR. And finally, somebody called them out that they just had blank spaces in the terms of service, like insert governing law, insert limitation amount. Yeah, right. So I think the biggest thing is openness to risk, kind of dovetailing with some of the points here. For most of our early stage clients, they have to figure out product market fit within a year to 2 years and raise a bit of capital, even if that isn't full product market fit. And if they don't get that, often they're dead. So they're very open to risk because the company's not going to be there in a year to 2 years if they don't take certain decisions. I think the other difference, or another point that goes to that, is longevity as well. So with these big established clients, You're going to get longevity in the sense of one client. With a startup client, you'll get longevity often with the founder, but multiple companies. Because company one will maybe not work out. They'll work with you for company two and company three. So it's a different longevity of relationship, longevity with the person and not the corporate entity. And I guess the third is, as a lawyer, I think, depending on if it's the founder's first company or not, the lawyer's often relied on more for kind of pseudo business advice, kind of going to what Ryan said. A big company, they don't need that most of the time. They already know what they're doing. But you often get called on for these pseudo business questions that you don't really learn about in law school, but are actually probably the most fun part of being a startup lawyer.
Thank you. So a somewhat similar question, asking in kind of the differences of different aspects of practice. But what are some of the differences between representing startup companies on the one hand and representing the investment firms that finance startup companies on the other?
For us, we have probably 5 or 6 big venture funds we work with, but we're more company side. But when we are working with those bigger funds, I find they already know what they're doing. They've already done the deal terms. We're just papering whatever's been negotiated without our involvement. So my role is negotiating with lawyers on the minutia of the deal terms, but the actual nitty-gritty negotiating the deal terms are already done by the time it hits my desk. So it's more of a kind of technical role, but I defer to my co-presenters.
Yeah, no, I would agree with that. It, kind of goes to the level of sophistication of the client. When you're working with those VC investors, the basic, you're not describing basic concepts as much even too, as you're going through, the negotiations on the documents. Another thing I would say that just it goes without getting too into the weeds on it is, of course, there's going to be just slightly different interests of, working for the investor as compared to the company. So for a couple of quick examples, the investor is mostly looking for a return, but they also, in doing that, they want to make sure they have some say in how the business is going to be run going forward, because they, probably feel like they can add value to that, and they don't want, the company going off and doing something that might hurt particularly the value in their perspective without them having a say. So there's going to be certain, we call them protective provisions and things like that, that are going to be certainly investors are going to be pushing for. And the on the other side of that, on the company side, well, certain amount of that sort of approval process is going to be typical in market, and the company is going to expect that. The company also just wants to make sure that there's a balance there, and that they're not really kind of having their hands tied so much by these investors that they're not going to be able to run their business day to day. So that's sort of one of the tensions that you see in terms of the differences between the interests of the VC investors in the company. But of course, there are many, and they will depend on many factors. But so that's a couple of other considerations.
Yeah, and I think Katie and Kellen really covered a lot of it. We also tend to be more of a company founder first firm as opposed to investor firm. Firms that tend to deal with fund, like if everyone's looking for wanting to work for a VC fund, you might want to work for a law firm or look at law firms that offer like fund formation services. They probably tend to act more for funds than companies. Maybe just piggybacking up, just the final thought would be investors tend to be more focused on their protections. They want to negotiate maybe different special rights, liquidation preferences, if anyone's heard of those things. They might want to look to get paid a little bit more in the event of an exit or an early exit, or as a higher hurdle rate to get return. These things tend to come up more when funds are tight, like the last year or two. Some get a little more creative with terms. Some try to bring back terms that Silicon Valley had mostly killed until Canadians revived them. And then on the company side, it's a lot of coaching of, what's reasonable, what's not reasonable. Investors tend to think when on the company side, when we act for companies, investors tend to tell them or advise them that there's only one possible way to do this deal, and it happens to be the way that it's being presented. And yet magically we come up with a few other ways to do it, and we might remind them that maybe they can just ask if that's needed. And sometimes when our clients push back, the companies can find a ground or approach that we think is more middle ground. So it's just recognizing that contrast between pushing back and supporting your companies, while also making sure that investors do get something that they need to make the deal, because if both sides have to make a deal, and there's a zero-sum game to be had at certain points.
Yeah. So thank you. And Ryan mentioned fund formation and kind of different offices that focus on that. I would mention so Laura Webb is not with us today. She did the same event last year, and her practice focuses a lot on fund formation. So apparently, Osler is one of the offices that does a fair amount of that work. Okay, so the next question is as you know, the three of you, kind of focus in the startup realm. Could you each tell us what do you like about working in the startup and emerging company space? And is there anything that you dislike?
Sure, I'll start this one off. I really enjoy my practice. I think some of the things that drew me to this space and that have kind of kept me here is that the practice is really dynamic, and it is every day is different. Every deal is different, even though there's sort of a general formula to some of these things. New issues arise. Ryan and I are actually just working on a deal right now together. We've had all sorts of fun little things come up. And so it keeps you on your toes. I think as well as someone I started out in this space as well. And it was a space I was learning. I didn't come into the tech practice. I wasn't an entrepreneur myself by background. I didn't have an engineering background or science background. I had a business background, and I've just sort of learned about this this sector as I've been practicing in it. But as you are coming up as a junior lawyer in this space, you have a lot of opportunity to work very closely with these companies, because again, we have such a large number of clients that we work for at Fasken. You're always working with 20 or more clients in any sort of given week, and so you just by by virtue of kind of the practicalities of it, as a junior lawyer, you are taking calls with clients on your own. You are doing things on your own, and you have a level of supervision, but you get a chance to really build up technical skills and understanding and client skills, and see the sort of the side of managing clients as well, from a very kind of early start. And I really enjoyed that. I think the looking at the associates that we have in our group, they're very strong technical lawyers, and I think it's a great area where you learn those skills very quickly. It's also, as I say, you're working with entrepreneurs who are often, around your age. They're doing really interesting things. I've always found it just to be, a really rewarding sort of profession in that way. And I like that, both sides have to get a deal done. Both sides at the end of the day can be happy with, the deal that is struck. And everyone's, celebrating a closing, and it's not that there's kind of one winner and one loser. In terms of the challenges, like any industry, there's going to be challenges. I think that the main thing I was sort of alluding to, just having so many clients that you're working with, I think one challenge is just making sure you're really good with time management. And that's a skill to be developed over time. And it's something that, you will learn as you go. And it's sometimes it is the case that everything falls on your lap on a Monday morning, and you're just trying to triage and get things done, but you learn how to manage that as well. So I think that's probably what I would say in terms of kind of a challenge, but it's not something I dislike. It's just sort of part of, navigating the profession.
Well, you just said everything. What would I add to that? Because that's all directly on point. I think the time management is definitely a challenge. And I think for us, at least, it's a volume-based business to get people in the door, and then you see how many survive. I mean, 20% of startups really survive. So we have like 230, 240 new clients a year. So for us, it's just remembering what's going on with all of those new clients, because every day you have new emails from different people, and just trying to keep track of that I find to be difficult. What I do enjoy the most is probably the kind of the business advising that I alluded to, and even more so negotiation on behalf of clients. A lot of our clients give us a lot of leeway to negotiate on their behalf. And I don't know, lawyers at other firms don't do that as much, but it's something we do, and we really do enjoy being able to kind of run point on behalf of our clients in different types of deals, and the negotiation that goes with that on real substantive terms.
Yeah, Katie made it easy for us, so I'm just tacking on and unequivocally agree, or for the most part agree. The really fun parts are the business advice. The challenging side of that is you've got high demands. I mean, you've got some really smart people who have probably made it successfully somewhere else. For the most part, the average client that we get that's a founder has been successful in their first domain, usually had at least one or two careers before. They've been so successful they can retire early, and they decide to put all that money that they've made from that one space, usually in like some sort of entrepreneurial space that they formed, or they've worked for a big company, got equity, got options, and want to leave and take that equity and respin it into something new. But you've got really demanding people who've done really great things. And it's one of the challenges is you've got some really demanding clients in the early days when their budgets are more shoestring. So it's how do you get practical advice early on when the budgets are just not really there? And so there's like a volume-based approach. There's a bit of a discount courtesy approach. It just sort of practically built into us. And for the most part, we try not to compete as hard on price. And a lot of it just, we want to find really great people that want to work with us, and we find a way to make it work. Sorry, I just had one thought on maybe just, I think it's also worth nailing home. One of the tough challenges, I think, as a junior lawyer coming up through all this space, you're not really there's no such thing as startup law. It's a big secret. I made this, I know we have to remove that from our websites. It's misrepresentation. No, there's no such thing as startup law, arguably not even technology law. I mean, we're corporate lawyers who know corporate law, corporate finance, M&A, some elements of securities law. We have to be able to know employment law. We have to we never give tax advice, but we have to know the tax implications of granting options when the company's worth something instead of issuing shares when the company's worth something. I mean, it sort of goes on for a long time, and depending when someone comes to see us, if it's not from day one, it's actually can be a little bit more complicated from year 1 or year 2 or year 3 when there's elements of cleanup, digesting, and yeah. So, for the lawyers that are looking to go into it, it's okay if it's a little bit chaotic for the first 5 to 7 years. But yeah, and then it just gets more fun. It's still similarly chaotic. You just learn how to ride that wave better. But emphasizing the difference between some practices where you just do pure securities, just do pure tax, just do pure M&A work where you're just buying and selling things. It's just, you've got to be able to interact with so many areas of law that it's almost overwhelming for the first few years. But we want you to all see the rewarding sides of it on the other side.
Thanks. Yeah. And then I might, just kind of add my own perspective really briefly. I was not a startup lawyer when I was in practice. I was a private equity lawyer, but I did do a handful of venture capital deals. So, I did a little bit of work for some of the venture capital clients that we had. So this would be on the investor side. But I remember, those deals, I thought that they were really interesting and really fun. And I kind of wish I'd had the opportunity to do more. And sort of my recollection was it was really just the companies that were being invested in were so interesting, and you got to like kind of learn about these companies, and they were like a bit more dynamic. Like in the private equity space, you're buying these kind of like sort of mid-stage companies that are already established, and it's much more about the contracting of the deal and like kind of like buying the company, but the company is a little bit more of a known entity, or at least the business due diligence is handled almost entirely by the client. Whereas on the venture capital deals, it was like you got to be on calls where they're really sort of digging in, because it's sort of an educated guess as to whether or not the company is going to be successful or where it's going to go. And so there's just a lot of dynamism to it. And I thought it seemed like a really interesting practice. So that was my experience. My next prepared question I have for the three of you is, how do each of you feel that you add value for your startup clients?
For us, it's probably two things. Like, as I've emphasized already, it's that practical advice that comes from either just how you view transactions, but also deal flow. As we talk about financing rounds, you do enough of them, you understand where the market currently stands, and so I think that's a big value add for our clients.
Agree with that fully, and kind of building off of that, I think one way that we can add that value is by helping clients, especially again, we work a lot on the company side as well. So, you're working with a startup founder, maybe it's their first time going through a venture financing or a sale process. There are hundreds of pages of, legalese for them to get through. And so to be able to explain in a succinct way what those things mean. And, to your point, Kellen, like what's market, what do they need, what are really the issues to hash out here, so that they have an informed understanding of what they need to spend their kind of capital with the other side on negotiating. And it allows them to make sure they're not kind of burning trust or burning goodwill with the other side. And just being able to, so I think to pull that back, being able to easily, in a digestible way, explain complex legal concepts to your clients is one of the most valuable skills you can have. And we hear it time and time again how much our clients appreciate that level of kind of distilling things down for them. And it's an acquired skill. It will take time to build up, but it's something that I think is really invaluable in this space.
I'm going to echo everything they both said. I mean, it's so important you've got to find clients also that fit probably your character and your ethos just as much. There's got to be a cultural match. It's a little bit like dating. You can't have clients that will always grind you for bills till the end of time, because that's not going to be fun, and you're not going to have the same fit where you want to work with them. You want to find clients where you're excited to work with them and they're excited to work with you. And lawyers are always expensive, and it's one of those funny things that we always say, we're always going to be expensive, but we're still trying to make sure you're getting way more value than we'll ever get. We get fixed fees and you guys get exponential equity, and you guys get to become, millionaires or billionaires or gajillionaires, and we can only charge so much. And a lot of the value add we have is just business advice, practical advice, life experience. It can also be a little bit more individual lawyer or team. Like in particular, I've got a lot of experience with like intellectual property licensing and service agreements and spinning up companies from day one, or how do they start growing and doing their first standard forms and drafting contracts. So I'll be there on the financing round, and as the teams are comfortable with me, I'll be there on the contracting rounds, and I'll be there on the scaling the contracts or working with them on as they're the small supplier for a big vendor, and how do we fit all that into the litigation conversations that things come up, or the employment conversation. So it's the value add also sometimes is just like an internal project manager of when we recognize that, hey, this is an employment problem, it's got to go somewhere, or hey, this is a tax issue and you need to ask your accountant. It's like, no, I know that other people are doing this, but you do have to ask your accountant. We've seen this be a problem on the tail end when you sell your company. And so a lot of that advice is just like from the start to finish and all the things that happen along the way.
That's what you learn in law school, issue spotting.
Yeah. Oh, I mean, it's been a while since I've been there, but yeah, issue spotting never dies. It's funny. The skills they teach you will be invaluable for you in practice. Humility too. Don't lose it if you can.
Yeah, we make you take exams for a reason. So I actually want to kind of maybe follow up on that a little bit. So it's something that Kellen and Katie said, but you kind of talked about knowing the market and providing your clients advice about the market. So that's something I always emphasize in my corporate transactions class, kind of based on my own personal experience, is just how important it is for deal lawyers to know the market and being able to kind of explain market trends to their clients. I just want to ask you if you could maybe expand a bit on that specific to the startup world. So like in my background, coming more from like M&A, private equity, even when you're working with very sophisticated clients like private equity funds, as a lawyer at a law firm, like you're just literally doing way more deals than they are, right? Because you get involved later in the process. So like you mentioned the volume nature of legal practice, right? But you're just like doing a lot of deals. So you might have like very sophisticated clients, but they might only be doing like a few deals a year. And right. And like sometimes you're working with clients where it's their first deal, right? So so what I've found is that if you're working with big corporates, they're going to have their own financial advisors, right? They might have an investment bank or something. So you're not, that's going to be the source of the market knowledge. But for smaller clients that don't have outside financial advisors, like to what extent are you just like literally educating your clients as this is the state of the market, this is what it's reasonable to ask for, this is even like kind of where pricing is on certain issues? Can you speak to that a bit?
I'll jump in quick and I'll pass it back to the two of you. I mean, for first-time founders, probably 80 or 90% of the early conversations are just pure education. What's to be expected? Vancouver tends to be a space that's really friendly on paper, so there's a lot of kumbaya when we enter conversations, and we also have to educate on the nature of nice people on paper don't always have the nicest of terms, and some terms are a little bit more aggressive. And here's the implications. I mean, 5% difference of equity now can be the difference of millions on exit. So it's inconsequential now. You can just give it to get the money. But sometimes you push back on things because it will have serious knock-on effects and life-changing effects later. Or maybe that's the difference between you breaking even and making $1 million or making no money when you sell your company if things do get tight. A lot of the education too, so I think high-level education is the early days of setting up a company. So what are vesting terms for founders to earn equity? When should you be granting options? What's totally inappropriate or what might be within a range of being appropriate for equity or options or just dealing with that sort of phase? Getting shareholders agreements in place. So we should all, without looking at each other, know what the market terms are for shareholders agreements in town, and just making sure that they line up with our expectations. For me, Katie, and Kellen, they probably shouldn't differ too much. And so depending on which hat you're wearing, so how does that line up? And then when it comes to deals, it's what's reasonable at that stage of the deal. Earlier stage deals might have a little more variability. Later stage deals tend to be quite harmonized. And then it just depends on if the company needs money really fast, whereas raising a ton of money, the deal terms tend to get a lot more aggressive in favor of the investors. If the company has more leverage because they've got more sales, the terms can be a little bit nicer.
Yeah, just adding to that, I think, looking, and I'll focus more on the deal side specifically. So, on financing deals with venture capital, financing coming in, there is a set of standardized, what we call the Canadian Venture Capital Association. There's a standardized set of investment documents that are used, and there are variations in those documents. They're kind of, square bracketed, terms, and those will kind of vary from, from year to year. Even in the 8 or 9 years that I've been practicing, we've seen really, really investor favorable markets and really, really company favorable markets. And so those things will kind of change. And so to your point, it's about, as a lawyer, understanding where those lie in the current raising environment. And on the M&A deal side, there can be lots. There's certainly, they're much more complex transactions, and there's a lot of pieces to negotiate when you get into the weeds. For example, I just recently had a transaction I was working on. I was helping a video game studio sell to another video game studio that was acquiring them. And the purchaser was a studio located just, let's say, elsewhere in Canada. And it was, we were working with across from a firm that we work with often, but that counsel just had a very different idea of what was market than what we thought was market. And, we went and pointed to there's deal studies, especially on the M&A side, that get published by the American Bar Association and by a number of different, law firms that will publish those sorts of studies. And so, it was kind of a matter of us, here's our evidence of why we think this is market, and the other side coming with what they thought was market. And in part, it was that, their client was pretty firm on these are the terms that they do their acquisitions on, and this is what's being offered. And we got some movement there, but that's, I guess, just a practical example of how, even though, that firm we were working across from certainly does lots of deals, we do lots of deals, we just had different perspectives on what was market. And so how do you get to, how do you bridge that gap while you try to find kind of some of the empirical evidence to support your side, and eventually someone has to cave or find some sort of concession. So
Is that gap in the term sheet?
no, it was.
Go ahead.
Just in case it wasn't, it was one of those, it was a piece of kind of, it was customary, terms in terms of like indemnity terms. It was specific indemnity provisions, which are not outlined in full in the term sheet. So it was a deal term to be determined in the definitive docs.
Yeah, I had a couple. We were representing buyers lately, and we were saying, well, the market is what we're willing to pay and do on this deal. So you can point to your deal studies, but here's the term upon which we're going to contract. But I would split market into a couple things. One, working with startups, there's the market for how you structure a startup. That is the same between Canada and the US. How you set it up, common shares, you issue a couple million, your YC safes. That's the market at that early stage, and it's static between the US and Canada. As you get to later stages, you do see a lot more divergence between the US and Canada on financing round terms. A Series B or Series A in the US is going to be massive compared to a Canadian Series A. So I think there is a big divergence between what you see in the US and Canada. Most of our clients are raising out of the US, and they're structuring their deal terms consistent with what the US market is and not what the Canadian market is. And we mentioned some of these firm deal reports. If you want to look at like Fenwick and West does a startup market report, I believe every quarter. So a lot of our clients are looking at what their American peers are doing when raising out of the US. And obviously they're going to get materially better terms, even at the earlier stage. You'll get a way higher cap on a safe in the US than you ever would in Canada.
Yeah, thanks. And then maybe just to clarify for the audience, which is primarily law students. So I've been using the term market, and our panelists have been using the term market. And that's something that deal lawyers say a lot. They'll be like, oh, this is market or that's not market. So just to clarify what that means is that's just a reference to like the prevailing terms or the prevailing norms in the market environment, right? Which fluctuates depending on the financial environment, right? Depending on the business cycle, depending on other factors. But kind of like everyone is sort of like, the idea is that there's a market, sometimes it's more pro-investor, sometimes it's more pro-company, and it kind of, moves back and forth. And part of the way, I would say that you add value as a lawyer is kind of being abreast of what's going on in the market and being able to, give intelligent advice to your clients about what is or is not reasonable. Okay. So, Ryan, I think you had an aside about how things work in Vancouver. So I want to ask a question sort of specific to working in Vancouver. All three of you work in Vancouver. How would you describe the Vancouver tech environment specifically, either from a business standpoint or from the standpoint of lawyers working in the area?
I guess the Vancouver tech market, in my mind, really hasn't changed in 10 years. It's been a market looking for some big liquidity event from which you'll have a PayPal mafia type situation coming out of it. For those that don't know, PayPal mafia, a bunch of people made money with PayPal, Elon Musk included, and they started a bunch of other companies. And it was a huge capital event for the Valley at the time. There haven't been any huge exits in Vancouver. Hootsuite was supposed to be one that hasn't happened. Everyone's hoping for Clio. So Vancouver's a market with a lot of small companies and some mid-sized companies, but there isn't enough capital in Vancouver to push those companies to that large scale. If they are getting to that large scale, like the Clios, which are definitely the outlier, it's all because of U.S. capital and not domestic Canadian capital. So Vancouver's not a bad tech market to work in. But if you look at it relative to other market reports, they put out startup ecosystem reports every year. There are many US cities that would rank ahead of Vancouver. That's not to denigrate Vancouver, but just to say that the reality of being a Vancouver startup is a bit too it's not the strongest if you just look at Vancouver. I think you have to look at the West Coast generally as a Vancouver company. And so for us being US lawyers, we're just not looking at it from the lens of Vancouver. We're looking at it from a US centric position as well, especially down to the Valley. But also for our practice, we're working across Canada and not just in Vancouver, and obviously across the US as well. So I think if you want to be on this very niche part of law, startup stuff, I think being a lot more global in your outlook is a good way to counteract that smaller reality of the Vancouver market.
Maybe my perspective's a slightly different one, just in that I've always focused really solely on Vancouver. And I was called in 2016. So I've been practicing for roughly 8 years as a called lawyer now. And I would say that I've found that I've seen, there's a lot going on in the ecosystem. There's tons of events. We recently had the BC Tech Awards that took place, I guess like last month, I think it was. And there's, I don't know, 800 people in a room and lots of recognition for the community. So I do think it's like a close and tight-knit community. You start to go to events, you start to see lots of the same familiar faces. And similarly with the bar itself, as we've kind of been touching on, it's a pretty specialized area in lots of ways to work with these startup clients. And so there is kind of there's only so many lawyers that actually do this work in the city. So you start to get to know the people on the other side of the transactions. And oftentimes you are working across from U.S. counsel because as Kellen alluded to, company side investment, you're getting a lot of investment out of the States. But when you're doing things domestically, like, you start to see the same names and faces on things, which I personally just really enjoy. You get to kind of build some collegiality with the colleagues that you're working across from.
Thanks. How many lawyers do you think that we have in a space that we regularly work with? 30? Do this work? Yeah, 30, give or take? 30 is the max. 30 yeah, in Vancouver. So it's for context for everyone. I mean, we would probably guess there's maybe 30 lawyers that would do this work pretty full time in the city that would, we'd regularly see their paper and we'd sort of expect it to be roughly like our own. And depending which side of the deal we're on, we might push and prod a little bit here or there. If Kellen's acting for big bad buyer, he might push over here. And if he's acting for the good guy company, he might push differently. No, but it's also worth putting that into context. It's a smaller market in a good way or a fun way if that's what you're looking for. If you're looking for the biggest deals in in Canada or generally in this space, you have to go south or you have to go east, more or less. If you just purely want to do corporate finance deals, you might have to go bigger somewhere else. Vancouver tends to be companies that there's lots of builders, there's lots of tinkerers, there's lots of entrepreneurs. We're super entrepreneurial, but a lot of companies are either bootstrapped and they're entrepreneurs that we've never heard about that still sell their companies for 10, 15, 25 million privately to a random private equity fund. And you've never heard about these sales, or they get a Series A, and then they tend to leave Vancouver and grow in America, where their customer base happens to be for the most part, because the economy of California tends to be around 5th in the world, and Canada's around a G9 to 11 country technically. So just being mindful that we're great at what we do, but it's not the end all be all. And so just the tech market's fun and exciting, and there's lots of early stage focus. Just not as much late stage. For now, not until people exit Clio and start reinvesting their funds here.
Yeah, so I guess I've actually done a little bit of academic research in this area, and by Canadian standards, I mean, so Vancouver is a is quite dynamic as a kind of a hub for startups by Canadian standards. I think there's probably more activity by volume in Toronto, but that's only because Toronto is a bigger city. Toronto is like twice the size of Vancouver. Per capita, Vancouver is actually the most dynamic city in Canada in terms of both startup companies and fundraising. But, sort of to Kellen's point, I mean, I think the reality that, anyone working in the startup world would acknowledge is just the like utter dominance of Northern California globally as a source of funding in particular, right? So like a lot of the mid-size and larger startup companies in Canada end up getting funded with US money because that's just globally, that's really the center of the world in terms of venture capital. Okay, moving on to the next question. This is a fun one. Could each of you share with us one of the most difficult or unusual issues you have ever faced working on a deal?
Yeah, I was thinking about this one. I mean, I don't have like a really funny, like great, perfect example, but I had two things that sort of came to mind. One is just I remember one time in an M&A deal, it was a couple of years ago. One thing to think about, and everything's moving more electronic these days, but still very often, you've original share certificates, at least that have been issued in the last 10 years for some of these big companies before they're being sold. And it was like the night before closing, and we had I think it had been an issue this whole time, but I think the company thought they'd find it. There was one missing share certificate. And so when the purchaser is buying the company, they want to make sure there's not some rogue physical share certificate out there that says, Bob Smith owns 100 shares when they think they own all the shares. And so one of the deliverables on closing is to deliver all these canceled original share certs. And it was like the eve of closing, we still didn't have the share cert, and we had to get this person like drive out from, I don't know where it was, somewhere like, I don't know, maybe like out in the Fraser Valley or something, not like super far. But he had to drive in and basically sign this certificate of affidavit that this share certificate had been lost. And that was like, it was holding up the deal. So it was kind of just one of those things that it stuck out because it was unique. And it was just kind of this like fluster, it's always busy trying to get to closing. Everything's, all these last minute things coming up. So that was one of them. And then another one, just more broadly, I would say, in terms of kind of one of the more difficult things that you can have on transactions, I was thinking in the financing space, is sometimes when you have a strategic investor. And so what I mean by that is someone who's not simply a financial investor. It's someone who is either, from a company, like a company that wants to invest in a, potential sort of competitor or similar company to them with a view to one day potentially purchasing them, or like a VC arm of large organization that again is looking at possibly acquiring this company in the future. And so there's some unique tensions that come up when you are having a strategic investor come in on a financing transaction, largely again when I'm talking about kind of things like approvals and protective provisions and control that they might have over the company, because you need to sort of balance what that investor's expectation is in terms of things that they're going to have approval rights over, while also not kind of boxing the company into a position where this investor is going to have so much control over their potential like future sale process that effectively you've kind of locked this company into a position where they're not going to be able to get a viable competitive bidding process from other potential purchasers, and they're kind of forced to sell on maybe less favorable terms to the strategic. So I think that's one area where when you do have a strategic investor, I just find there's a lot more academic, thinking through scenarios in places where, terms that are otherwise somewhat standard can cause more issues for the company by sort of allowing that investor to get those sorts of terms.
Story time? Okay. I'll tell one story from last year and then a new one. Way earlier in my practice, I had a client call me up and they said, hey, we just took money from this guy, but we need to give the money back, but we spent it all. And we just found out that he left prison the day before he invested, and he was an enforcer for the gaudy crime family. So we need to get this sorted out. So we had to work on a loan type document to pay this guy back, knowing that he was the kind of guy that didn't like being stiffed on money. So that was an interesting one. Another one we just had recently, big Taiwanese company that you'd all know. They like getting into tech investing, and we had a client that had to close their Series A or they were going to go bankrupt. And this company just disappeared. They said, eventually we'll review all the docs, but it'll take 6 weeks at a minimum. We said, we're closing tomorrow, so you don't have 6 weeks. And we had to negotiate with the lead investor on that round to let them just forget about this investor signing the docs and we'll do it after closing. And we were able to do that. But if the investor hadn't agreed, the company would have been dead. So interesting problem.
Yeah, I'll try to put up a quick anecdote. To the question I asked the panel earlier about how many people in town practice this type of law, really seasoned people or groups of within firms where you trust the work. We had a file where we inherited a client, a company, a venture company from another lawyer. And so it's one of those, I'd just say that the paper wasn't what we'd expect. They had a unanimous shareholders agreement, required unanimous approval to amend it. They had already raised a bunch of money. So the problem with unanimous shareholders agreements is you might need everyone to consent to change it. And so what happens when you've granted options to employees who are now shareholders and you fired them? Do you think fired people are going to want to consent to change things? Or are they going to be more incentivized to hold out just because they can screw with you, or they might ask for money, or they might ask for something? And so we had a situation where there was, I think we had to get something like 70 or 80 shareholders to unanimously agree to amend and terminate a shareholders agreement, change some of their share investment rights for one class of shares. The lead investor had a very creative way of interpreting how the paper should convert for share rounds. And what I mean is it wasn't really on paper, and it was sort of what they felt like that week. And we had to pull that together and get about 80 people to consent, and just recognizing that if you don't get things sorted out in the early days, it's really the importance of having lots of flexibility, not paying yourself into corners like Katie was mentioning, knowing who you're practicing with and making sure that the paper is going to work with you throughout the life cycle. Because if you don't, we had to convince 80 people to read something that was more complicated than most lawyers would probably deal with on a weekly basis. And if any one of them held out, the transaction would have failed and they would have went bankrupt, because we funded on Monday at 5 p.m. and payroll was Thursday that they weren't going to make for 40 people. So 40 people would have lost their jobs in the tech community, and we would have lost a really great company coming out of Vancouver, but for some things that you inherit. So just being mindful of what you step into and keeping flexibility in a space is paramount.
And am I correct in assuming that a statutory unanimous shareholder agreement would be relatively rare? That's not.
Yeah.
Well, like a CBCA unanimous shareholder agreement.
Yeah,
like that's not something that you would advise a client to do necessarily.
Yeah. So for context, Ever, I mean, most for those in the room, most of Canada has a different scheme for shareholders agreements, unanimous shareholders agreements, USAs. The federal has it, Ontario has it, Alberta has it. I think Nova Scotia, New Brunswick are harmonized. Come on, look at the Scotia lawyer. You're the Scotia. Okay.
We don't incorporate in Nova Scotia.
Okay, there we go. All right, so it's these statutory protections that might be common in other places. And does America have USAs?
No, that's part of the reason I asked. Is
yeah, okay.
there's no, there's no statutory. You would have shareholder agreements, but they would be more flexible because it's just a shareholder agreement.
Yeah. So just for the folks in the room, it's just recognizing that sometimes the law in different jurisdictions matter. It's why if you're practicing federal incorporations with a CBCA or Canada Business Corporations Act company or corporation, it's different from BC, or it can be. So it's part of the reason why you have folks like us that specialize and care about this, the nuanced differences between being federally incorporated and registering in different provinces or being registered in BC. Because it can lead to a lot of problems down the road, especially if there's a rogue shareholder who says, no, I'm going to make an argument that we do have a unanimous shareholders agreement because everyone has signed on to it. And at law, they might actually have a decent argument to complain about that.
The only thing I would add to that is I do see unanimous shareholders agreements often. I wouldn't say there's any reason not to use them, but to Ryan's point, you wouldn't want to have the amendment provision require unanimous approval by everyone.
Yes,
and so there are reasons to use the unanimous shareholders agreement. And even in BC, very often we'll have all shareholders sign on to it so that they're subject to powers of attorney and things we want them to be subject to. But you certainly don't want to have a threshold to amend or terminate be unanimous, particularly when you have 70 shareholders. That would be the key issue there.
Okay, great. Next question is, how has your practice changed over the years, either personally or due to changes in the industry?
I'd say the technology that you're working with changes, obviously, right? Everything was cloud, then there was something in between, then everything was Web3, and now everything's AI. And so the type of companies you're working with are changing. Now, what we do to structure them and finance them, that's largely the same outside of crypto, which had some weird token offerings, but it's largely the same between most tech industries that have evolved as I've been practicing. But what you are learning as you go along with all these new technologies are that there's different areas of law that are implicated that maybe weren't as important as they were for other types of technology. You look at like crypto, yeah, there's securities on all of our deals, but our clients were doing token warrants and things like that that involved a lot of complex securities laws. So that changed a lot of what we were doing as a practice as it related to that new area of technology. Nowadays, too, privacy laws are getting way more complex, obviously in Europe, but also even in, let's say, California and other US states. So as technology is evolving and more information is being collected, we're also seeing that the laws are evolving and becoming more complex. And so as a practitioner, we're having to really stay on top of that, which makes things very interesting.
That's great. And I won't even, I think that was a really good summary there. On the other side of it, in terms of the like practice management side, I would say is another thing I've seen changing. And, that's natural evolution, and particularly with, the rise of, large language models and AI and things like that. And so one thing I think, at our firm, we have kind of an innovation team that is on top of like looking at what's out there and trying to incorporate these new technologies while also being mindful. One particularly, really important thing is that it's we're still protecting our, solicitor client privilege and the, protecting the privacy of our client data. And so there's been a lot of work on that. And but at the same time, as a firm, the products that we have kind of approved that are ready to use, there's a lot of encouragement for us to be using these sort of AI tools. And I think the message that we're sort of hearing is, AI is not going to replace lawyers, but lawyers who use AI well are going to replace lawyers who don't. And so I think that's really kind of the message that's being reinforced with us. And I think all of us are trying to make an effort to start using those and incorporating those. We have, sort of even within our technology group for startup companies, we have kind of a new platform that basically takes a questionnaire that a client will fill out and automatically generates their kind of startup documents, which we're still working out the kinks on. But, the goal there, of course, is to be more efficient and save time and costs for our clients.
Yeah, I won't even touch either of those because I think it's important to recognize that what we've done to be how we became lawyers is going to be different from how everyone in the room is going to become a lawyer and what you're going to start on. I mean, right now our firm has a mandate where they tend not to want junior lawyers to use ChatGPT for research or LLMs for research for a while, and I'm not sure how that's going to change. But when I work with students and junior lawyers, I try to force them to work on some of my things in a controlled manner with AI and LLMs. One, so I learn how to use it, and two, so they get a chance to be exposed to it where it's in a controlled environment. I think the other change of the practice that I'd say is because AI is in everything, not just from a financing standpoint, I'm way more mindful of intellectual property ownership from day one and things like who owns the data, which tends to be the user, who should get the license or the right to use the data or manipulate it or do things with it and change it and grow it and train their models or not, tends to be the company. I mean, for those in the room who want to go on their own, if you look on ChatGPT's terms of service, that tends to be roughly market. They tend to conform with Azure. They tend to conform with Anthropic and Perplexity. So just even recognizing that the big companies of the world in this space are sort of drawing terms that are going to have knock-on effects for us. And the biggest change for me is in the last year, virtually every startup that comes through my door of financing or that's coming through the door for a new venture, that's financing, that's growing, that's scaling. There tends to be an AI component. We've got to be thinking about the data, the ownership, the insights, the licensing rights, and just have those baked into agreements from day one. Whereas before that would have been a complicated file or complex. It's sort of table stakes.
Okay, thanks. I guess my next question is, from your perspective, what is the current state of the market? And, the context here is, we had there was kind of a deal frenzy during the COVID years, and then interest rates went up and financing got cut off in a number of ways. And so I think the financing market, for startup companies, for mid-sized companies, for everybody, really dried up pretty significantly. So what do things look like, in, like third or fourth quarter 2024?
Yeah, I'll say we're definitely seeing more people call us for new ventures. So things were incredibly quiet in the venture financing market. 2023 had sort of a big push for financings, maybe early 2023. Then it got quiet for financings. It became more common for exits and sales. 2024 has been fairly quiet all around, and I found at least for us, it's only starting to pick up now where we have more financings and more sales at the end of a year. I've also had people that have been working on projects for the last year or two in stealth mode, and we're getting a lot more phone calls of, hey, I've got something, I've built something, I want to raise money to grow it. Whereas before in 2021, 2022, 2020, people were raising money before they really had much of a product, if at all. They sort of had a rough idea. They might have had a wireframe that they could put on a computer, do a demo with. They didn't really have a tangible product. Whereas now we have people who've been building, testing. They've been in the market operating without terms for a while, and now they actually want to do something. So we're picking up with new activity, I'd say, for the new ventures, and it's getting exciting again. And things are further along than they would have been in the past. So I think all around it's better for the market and better for everyone that we've got more developed, further along companies looking to raise money that are just a little bit better off in terms of being solid businesses.
Yeah, I think, from my perspective also, optimistic about things picking up and in terms of particularly, I'd say financing activity. There was a long time kind of last year and even kind of through a lot of this year where a lot of companies were just trying to bridge to the next round, like bridge meaning, so, a company might do a seed financing early on, kind of raise a significant amount of capital to kind of get to their next growth phase. And then the market took quite a turn where it got to be very investor favorable, not so company favorable. Lots of investors were being really scrutinizing investment opportunities, and it was harder for these companies to find that sort of opportunity to raise into their sort of Series A, which would be kind of the next logical time where they would raise, sort of 10 million plus. And so they were just trying to, we call it like bridge to that, to get to that next financing, and just kind of, then oftentimes that's done through like convertible notes. So basically debt that's going to have a high interest rate because interest rates were so high. So it was companies, again, just trying to kind of survive, get themselves a bridge to kind of keep going, keep building. And like that next financing is going to hit and we're going to get that great valuation like we did in 2021. And those valuations are I don't think we're going back there. Like I think there's been a real correction that was needed in the market where arguably things were getting a bit out of control with how much, investors were valuing these companies. Just kind of, there was a bit of this FOMO and everyone wanted to get in on things. So I think there's been a good correction in terms of valuation, but I think we're getting back into kind of what we were seeing in kind of 2019, 2020, where there's financing activity, and it's not going to be crazy for companies, but good companies will get financed. It won't be quite so much of the like do or die for folks as we've had for the last little while of those like almost bankrupt kind of scenarios. And then on the M&A side, that also seems to be picking up. I'm seeing larger deals happening, which again, hadn't seen as much of that in the last sort of 12 months. And I think there's still a little bit of a trend on the M&A side of deals taking a bit longer. Like we're not in that flurry phase where people are just trying to get deals done in like record time. Investors are doing their diligence. They're, making sure the valuations are supported by what they're seeing. But I think there is an appetite for more of that. And so I think it all looks encouraging that we're getting back to kind of, I don't know, the norm, if you will, if there is one. But
I would agree with most things here. I'm looking at it from more the US lens. There's a huge IPO backlog, including for a number of very large Canadian companies that will be IPOing, and they're in the queue for it. 2025, 2026, depending on where things fall. So I think there's going to be a lot of economic opportunity coming out of those IPOs. The US is entering a deregulated period. We can like Trump or not. I'm not going to weigh in on that. But I think there's a lot of expectation that interest rates are going to be lower, and there's going to be, with the deregulation, a lot more of a economic environment that's going to make deals move faster, and potentially higher valuations. So at least talking to some VCs last week, that was their view, agnostic of the political situation. I think as well, we're going to see a lot of people coming up to Canada, setting up here. We saw that a lot during the first Trump administration. And a lot of US companies had trouble bringing people into the US, so they set up Canadian operations to bring those people into Canada instead. And so I think we'll see a lot of that, which will lead to its own set of economic opportunities. So that's my thought on the market.
Okay. Sounds good. So why don't we move to our final prepared question for the day, which is, what advice would you give law students who are interested in exploring your practice area?
Ooh, good question. You can teach yourself most of what you need to know about this industry. We've talked about what market is, and you can find what market is on the internet. Yes, you can use ChatGPT, but Y Combinator safes are how you raise capital for most early stage companies. So go to YC's website, read the safe, understand how it works. Go into those national venture capital documents. The US and the Canadian are very similar, and they're all online. They're dense, and your brain may not enjoy them, but
And, take corporate transactions.
take corporate transactions. Yeah, you'll be such a stronger lawyer for it. But yeah, I think there's a lot of information out there, so you can learn, a lot of things you need to know in this industry because it is around standardization, has been alluded to. And for when we're hiring people, I expect people that are actually interested in this space to have done that beforehand, so we don't have to teach them what a safe is and why that's different from a convertible note. So go check the internet.
Yeah, and also, one of the nice things too is there's a lot of like interesting podcasts and just however you get your information. And I find like I just listen to podcasts when I'm walking into work or going somewhere. And there's lots of interesting ones out there to kind of help you digest things maybe in a more fun way too than just reading these pretty dense, to give yourself a little break in between reading the CVCA docs. The other thing I would say and I serve on the student committee at Fasken. So also just thinking about the strategy around kind of if you're a student and you're interested in this space, I would encourage you to meet with people from different firms and actually talk to them about what their technology practice is like. As I sort of touched on earlier, I didn't know that I wanted to be a tech lawyer when I was in your shoes. And I luckily ended up at Fasken, which has, we actually have about 30 tech lawyers that do different aspects of the practice, not all transactional. And so I ended up at a place with a robust tech practice that I actually could really plug into really easily. But, talk to the firms, find out what their team looks like, find out what type of work they're actually doing, and figure out if it's a place where you might want to land. Because I think doing that research about the firms up front before the OCI week is helpful because there's so much going on once you get in and you have sort of 3 days to decide where you want to go. It's really helpful to kind of do that up front. And our students, our associates, partners like myself are always happy to talk to students as well and go for coffees and things like that. So that would be my other piece of practical advice.
I'm gonna do the same thing and echo off both of you two. Katie's so right. I mean, you have to ask people what they do and what their practice is like, and every firm's also a little bit different. I mean, bigger firms like Fasken will have a different approach, and it's probably a little bit more structured, and it's probably a longer apprenticeship, and it's probably more formalized, I would speculate.
Still, it's the Wild West out there,
Fair, yeah.
But we've got a lot of resources. We have a lot of training, all that sort of stuff. Yeah.
Yeah. So, and you should be asking those questions. What training do you have? What sort of technology do you use? How do you empower students, and what sort of technology are they expected to use early on? What sort of files would they be exposed to? When would I be chatting with clients as opposed to being more behind the scenes? Or, what would I be doing as a summer student, articling student, first year, second year, third year, fifth year? If you can ask those questions and understand how that works at Katie's firm and Kellen's firm and at Harper Gray with me, like, we're all going to probably do it a little bit differently, and none's right or wrong, but just be mindful of what you're setting yourself up for. Maybe just on top of that, to digest the documents faster than just reading them, because we don't always like them and we're getting paid pretty well to read them. If you follow me on LinkedIn under my name, I've got a curated podcast selection. I throw things in there. I throw great podcasts that are worth learning. That's sort of a what should first-time founders know, what should early entrepreneurs know, would be totally great for law students. We said the name a few times, Y Combinator. For those that have never heard of it, the letter Y Combinator. Follow them on Spotify or Apple or wherever you get your podcasts. They've got great resources. If you go back through Startup School, they've got a 10-episode podcast that's covering most of what we talked about today. It's funny that the last episode talks about legal and the first 9 are talking about all the fun stuff. So you should learn these things, and they're sort of the starting point before you have conversations with a lot of us. And if you can digest the 8 or 10 hours of podcast on faster speed, you'll be ahead of most of your peers, and you'll be ahead of most lawyers and founders in the space.
Just a wealth of knowledge. Watch Silicon Valley on HBO. It's actually 100% accurate as to what you deal with on a day-to-day basis. But it's not. But humor aside, Ken Adams on drafting, go buy the book or buy the ebook. It should be mandatory in law school if you're a corporate lawyer. It has 10 pages on the use of the word shall. It's all about how to draft cleanly and concisely without extraneous language. And for me, it's a prereq for any good corporate lawyer. And I think you'll learn more about it than in any other class in Camden's, which is a great class.
All right. Well, thank you so much. That ends our formal presentation. So why don't we give a round of applause to our panelists? Thank you. And we've got 5 or 10 minutes for questions. So why don't I just open it up to the audience and let you guys can field questions.
Sorry, that was too hard. So this whole field is really exciting to me. And I think you mentioned something earlier about, getting clients through the door, and someone said about having 200 clients, something like that. I'm wondering if you guys do work for like incubators, because I feel like UBC as a hatchery, for example, legal advice is sort of the common denominator, and your legal advice can actually help 50 different spin-offs that are coming out of the hatchery. I wonder if that work is being done, or if there isn't, is there space to do it?
Work with some incubators, but I don't do the ones that you pay for. So I've approached incubators years ago saying, look, we do the US, none of you guys do US. There's the value add. We're not here to sell, we're here to educate. Most of the big incubators require the law firms to pay a substantial sum of money. And I've never played that game, but we are involved with a number of incubators, especially on the East Coast, where there isn't. It's more just provide advice for free, which is exactly what I'm willing to do.
Yeah, we're involved in terms of like educational sessions and things for some of the companies that go through those, but like we're not legal counsel to any of the incubators or anything like that. But yeah, we spend lots of time going to events with them and just trying to get in there and give informational sessions about things that founders should be thinking about.
Yeah, I'm also going to draw a line between an incubator versus the companies. We tend to always act for we tend to almost unequivocally act for the companies. So a lot of the companies will still tend to find us or find other folks. I mean, if you Google startup lawyer Vancouver, you're probably going to get most of our names in it. Well, it's your SEO this quarter. Right. So you get a handful of these things. So a lot of them will come to us anyways. We educate by hosting, networking events or evening events. I'm kind of constantly out there, and I try to get my junior lawyers with me out there to chat with folks. Not that it's not a great idea. Part of the other challenge might be to navigate either payment or acting or conflicts, because once you've given free advice to someone, if you're still giving legal advice, there's future conflicts without any sort of like remuneration on the other side. So I think that'd probably be one of the biggest challenges you'd have to navigate. Offering legal paper that could fit for those coming out of the incubator might be a way to do it at scale that could work if you're trying to tackle that. But just having someone come up for one-off services, it's sometimes also challenging just to navigate conflicts in the moment. If someone's to drop into our office, I mean, my conflict check is pretty fast and still can take an hour or two. Sometimes I can do it in minutes if I'm taking a little risk and making sure that I'm not really getting any hits in my system. But even those little logistical things of who would be the client, what kind of legal advice would they be getting, what kind of help, what's the scope of it? If you're trying to look at that, I just think about those things.
What are some of the more, like you said, formulaic aspects of your practice, and what are some of the more, I guess, nimble or changing aspects of your practice?
Yeah, high level, the formulaic stuff tends to be the financings. And when we mention financing, maybe just worth saying, we tend to mean, or at least I think we tend to mean, you sell pieces of your company in equity for money, right? You get a $2 million valuation by selling 10% of your company for 200,000, or $1 million raised for 10% of your company is $1 million valuation on some fronts. So when we talk about valuations, we tend to mean things like that or financings, and those rounds tend to be formulaic in the framework. There tends to be a term sheet provided by venture investors, or we should guide our clients, the company side, to talk to the investors and have them present a term sheet that they're comfortable with and that most people will invest under, if not all of them. And then we should help guide them through that process. And a lot of the paper is very formulaic, like it should be standard venture paper. For those Googling it, the model CVCA documents, like Canadian Venture Capital Association documents or other ones. So that's formulaic. The stuff that's not formulaic is like when it comes to IP, service agreements, we try to have standard frameworks of these services are happening and who owns data and who gets licensed to do what, or who pays a subscription to access a platform. But it gets really custom fast. It's just sort of the nature of services.
Yeah, I think you did a good job of summarizing it. And I think just, day to day, like the non-formulaic thing is that you're going to get a bunch of surprises. The company's going out and doing some things and you've got to react to it. So there's a lot of things, and to Ryan's point, the financings can be fairly formulaic, but there can also be, again, unexpected issues that pop up. Trying to be creative and problem solve where there is some reason why this standard term presents an issue for the company for XYZ reasons. So there's an aspect of the formulaic approach to things, but you do get to be really creative, I think, and like solve problems and be practical and find those solutions for your clients. And so I think that's something that is a really fun part of the job.
You guys covered it. I'll leave it there.
Kellen slightly mentioned the effect of Trump, like incentivizing bigger companies to open shop here to hire people. But like on the other hand, they recently announced that the next administration going to exempt U.S.-based companies from capital gain tax for crypto coins. And so I guess the trend is going to continue with other industries as well. Aren't you concerned that like this would incentivize like founders to like move their companies to US, like because they're basically their biggest customers are in US, and if the US continues to be protective of their borders, like in economic sense, like it's no longer makes sense to have like startups in Canada?
Yeah, for us, we don't care because we're U.S. lawyers, so we can redomicile a company from Canada to the U.S. really quickly. So for us, it isn't an impact on our business. It's more just applying the same skills we already have. We always have seen Canadian companies going down to the U.S. If you're setting up in the U.S. and you're becoming a tax resident there, then yeah, you got to take advantage of that. The fact pattern for most of the companies we have, though, is they still have teams in each country. So it's a question of figuring out which is the parent and which is the sub. And there's a lot of personal tax questions that go into that. Because if you're a U.S. company, but you're all in Canada, you lose out on various Canadian tax exemptions, and your money's going to have some withholding tax. So you might see more people going down to the U.S. I certainly have had that conversation recently. I'm seeing Canada as a cost base for development teams, though. That's always been the case. I just see that increasing due to immigration challenges into the U.S. But for our practice, we see the U.S. and Canada quite seamlessly. So if our clients want to go down to the U.S. and structure there, then that's no problem for us.
I feel like you're the U.S. Do you want to?
No, the only concept I'll say is it just also sometimes is the way that these things go where founders tend to follow their clients and you tend to relocate to America. I mean, a lot of our clients will start in Canada. They've got really great businesses here. They're the founders, they're the tinkerers, they start here. But the reality is after around Series A, most of them go to America or somewhere else anyways. And the somewhere else, again, really is not outside of the US. For the most part, Canadian founders tend to leave and go to America. And that's sort of the way it is. And it's Microsoft lost the handset war and the hardware war in terms of cell phones to other incumbents now, like Apple. They were really good at hardware way back then, and the times have changed, and now Microsoft does really great work with software. And so it's like, I still say founders should tend to focus on where they can do the best job and do the best work, and whether that's Canada or somewhere else. We're happy to help them start here. We're happy to help U.S. companies locate and get domestic help here. There's a lot of overlap, and there's a lot of reasons why you should stay or should go, but it's just recognizing the reality is founders tend to go to America because that's where the pull is for money or customers and so much more. And that's okay. I'm not trying to, have a stance on it, just the reality of the nature.
I might just add real quick. I mean, you guys are the experts here, but I mean, there are some pretty significant tax advantages at least for small startups in Canada, right? So there's like a lifetime capital gains exemption that's pretty significant for small companies. There's like
Tax credit programs for a lot of people, especially in BC.
and like for like technology research and development, there's like Shred, there's good tax advantages for that.
Even making sure you're a Canadian-controlled company until you don't want to be. Some of the deals we do, if you're a Canadian-controlled private company, a CCPC, you can take advantage of some of these tax credits or these different grants, or you can get higher portions of grants or higher portions of tax credits. And so we've got conditions of financing that the company will be a CCPC after closing because they want to keep that for one more round. So just, companies actually want to build that in. So they don't want to lose that until they're ready, and you shouldn't lose that Canadian ownership control until you want to. So just don't willy-nilly do it.
Yeah, I would say like probably the overall tax burden in the United States is less, just sort of as a generic matter. But I would say that there's actually more like targeted tax subsidies for startups in Canada than there are in the United States. Now, the hitch to that is if you're a startup, like you're probably gonna, well, not probably, but a lot of them are based in California, and so right, like you have to factor in state tax burden as well. Like so, California is actually, ironically, is like a very burdensome jurisdiction in a lot of ways. So, yeah.
Maybe just final thought on that. Just if you're also looking at taxes as a founder, we always try to remind folks that don't let the tax tail wag the dog too hard. Build a good business, build a great product, build a great team, and then start thinking about optimizing for tax. If you try to optimize for tax from day one, the financings tend to be too complicated. The paper tends to be more custom and tends to be more expensive, and it tends to lead to more problems down the road. So tax is good to be mindful of, but I think it's if you're making enough money and you're successful enough that there's always money to pay for some help.
All right. Well, thank you for the questions. We probably do need to shut it down, unfortunately, just because we're gonna have another class coming in. So if we have any remaining questions, I mean, maybe the presenters would be willing to stick around. I actually have to go teach, but why don't we have another round of applause? Thank you so much. Great presentation. Sorry to shut the Q&A off early, but we do need to vacate.
Oh.
So thank you again, and thank you everyone who came, and thank you to everyone online.
And Camden, maybe I'll say if anyone has questions
sure.
too, they can reach out to us directly. I mean, most of us are pretty active on social media or have emails, and some of us will be sticking around. So lots of ways to get in touch with the startup and tech lawyers.
Yeah. So take advantage.